have led by all witnesses. She has not given come up as DW1, DW2. Then court is directing, give the list of documents. The list of no. Where is 1A will apply? And how the judgment is applied? What is the right? Right of cross-examination, right of examination means destroy the case of the plaintiff's husband. For years together I will drag on. Because I am a wife. Is it the right? Right is only for one person. Right is not for the other person. Do I not enjoy a right to have a good life, quality of life have to be disturbed for years together, decades together? Is it not a violation of a right of unconstitutional? Do I not expect a quality life? If I fail, should fail, come. In my case is weak. Why you are dragging the matter? Dragging of a matter is also an important factor.
Yes.
Dragging of a matter also an important factor. Conduct. I will read below. I will come back there. I am showing you one. One is a compulsory. If you comply one, then the below other things come. Summoning one subgroup, two subgroups, and one. It comes. First you comply that. You have not complied. For that reason, court's order is not required. You are blaming the court. Good. What duty you have done it? First so.
Yes.
One now come. 7th August 2000. The date was fixed for further DW. Defense witness. You come. That is one. That is one. Come. No steps are taken by the defendant. Again, the defendant failed to file them. Now, that on 7th August 2024 was fixed for examination of the witnesses. You did not come with any of the witnesses.
7th of August.
Yes. 7th of August. Eighth August.
8th of August.
Oh, sorry, it is 27th August.
27th, yes.
27th. I'm sorry, 27th.
Yes.
27th August. I'm not, I'm sorry. 27th.
Yes.
Now, can you read now with this one? Come. One has to interpret in the facts of the case. Read one. Subject to the provisions of sub-rule 3 of Rule 1, any party to the same may applying for some under Rule 1, bring any witness to give evidence or to produce documents. On which date? Date fixed on the next day. Not on the basis of the date which will be chosen by any of the parties.
Date fixed by the court.
But you come. Why you didn't come? If you thought my brother is a very important witness for you, come. He is banking on my brother's witness and my brother's relative's witness. My relative's witness. I'm not, we are all aware in a society where we live. There are good relationships, there are also bad relationships within the brothers. If you are very important, why should I give in it? See, therefore, 1A is not applying here in this case. Because on 27th August 2024, he did not come with the witnesses for which the list has been given. But can you take it for? Today is fixed for further DW.
193. Give me a minute because some orders have been.
27th August 2024.
Mr. Bachat, your in the application order number 193 has been annexed.
My lord, 193.
193.
My lord, I have it here in case your lordship wants.
No, if it is annex, then I will go through that because otherwise here and there.
Relax.
No,
Annex.
it's not annex. It's not
Not annex.
Now, let me take this order. Today's fixed for further TW. Petitioner Shobhan Chatterjee is present by filing Hajira. No step is taken by the respondents to wife Srimati Ratna Chatterjee. Learned advocate for the submit that although this court repeatedly has given direction to file the list of witnesses and to start the copy of examination chief of the witness in advance, but the respondents wife did not comply the order of the court and as such necessary order may be passed. On repeated calls, learned advocate appearing on behalf of the respondent and submit that the witness as well as the could not come and accordingly has paid for passing necessary order into the register of local party. Advocate did not come. Okay. Why your witness did not come? My client was there. My client's advocates were there. Therefore, not 1A, even for the argument's sake, if I say not applying for argument's sake, although I have a different argument, 1A applying, that was exhausted on 727. That is correct. Kindly see the next order, 6 September 2020.
Yes. Yes.
Today is fixed for further DW petitioner Shobhan Chatterjee is present by filing Hajira. Respondent wife Srimati Ratna Chatterjee is present by filing Hajira. No witness is present. See. Now, on the next day, at this stage, petition is filed on behalf of the respondent stating intended that the respondent would like to adjudicate the 20 on our behalf. In the matter, since the petitioner had taken more than 3 years of time to adjudicate the matter by filing several petitions, including transcription and also such. Another petition is filed on behalf of the respondent for praying for appointment of advocate commissioner for taking evidence of witness results on the dark. The commissioner on the ground that the witness is above 70 years old and is unable to. And he is a member of legislative assembly 70 years. He can come to the assembly. He cannot come to the argument. He is a chairman of a municipality. He can get what he can do. He cannot come to the court. He is the person who was in charge of the parliamentary constituency election of Bhattacharyya. He has conducted the election, but he cannot come into the court. 70 years. And incidentally, I am 69 years.
Sir, আপনার অনেক energy আছে. You are young and youthful.
He is more youthful and colorful man more than me. You do not know. I am telling you. Fortunately, I know everyone and history. History, geography, everything. More colorful and more you can have.
Yes, Mr.
Can you come to the next day of that?
Yes.
Can you come to the last paragraph? According to concerning the order of the Honorable High Court, the evidence order to your respondent was instructed. Whom the respondent called to give evidence in view of the problem under order system 116. But the respondent did not file. Then, even today, the respondent filed a petition stating that the respondent would like to advocate to the honor club, but does not file a list of disclosing the names of the people. Since the Honorable Court has been pleased to observe that court has duty to see the proceedings should not be dragged for a wrong reason. In order to expedite the matter, this court has directed the respondent to disclose the names of the witness to enable the court to understand whether such witnesses are actually. Needless to say that the parties cannot be deprived for conducting their case. What is also the duty of the court to be that understand that. Just me. Malak, can you pause for a moment?
So, Bandhavadhyay, Mr. Bachchat, only one thing. Whether this order of number 194 was challenged by any of the parties?
194.
This order which Mr. Bandhavadhyay is facing.
No. No. This was not challenged.
This order is untouched.
Untouched.
But there were recalling applications on which orders were passed. Directing. No, that's okay. Don't get excited.
No, he is not excited. It seems that today you are excited.
No, there was a query from the court. I was asking. Army, sir, excited. Sir, Army excited. Army excited. Talk on it.
He knows that you don't get excited, but today you are excited. No. I am not going to that.
My mistake. I thought the court asked me about the.
No, I thought they asked me, so that's why.
So
That's
no
right.
question of being excited. But next week they filed two applications. One for recalling
Of this 194.
Yes.
for recalling of the order which did not allow the examination by commission by Mr. Dural Chandra, and they also filed a second application that they filed a list of witness and said that the list of witnesses is filed and that part of the order should be considered. Subsequently, to logically find from the order sheet, the court did not allow two witnesses, but first not the DW1 herself case.
Was this order set aside? 190.
No.
That is what I want to.
No.
Your lordship will find it in the order. It culminated in an order.
Mr. Kaur has said, kindly just about the legal provisions. So for one instance, let me
Just one order, your lordship will see
One
22nd of November. Sorry, 22nd of November,
let me-
it all culminated.
let me clear my understanding if I am right. At the stage of order 46, rule 1.
Order 16.
Order 16, rule 1. Discretion rested with the parties. 18, 20, 25, 30, 100. Two, the court has. Three, the court may reasons to be recorded permitted party to call whether by some.
3 is outside the list. 3 is outside the list.
Outside the list.
3 is outside the list.
Three outside the list and one at that.
At that stage, yes.
Then 4. 3 by side 4, then 1. This is some any party to the suit may without applying for someone to bring any witness.
That's all.
Next, 1 is this his discretion. If the court rejects, then the other questions come. This is not compassion. Court has given repeated time hereafter also. Give the list of witnesses. No. DW1 completed, DW2 completed, then submitted an application, 18 to 20 witnesses. Nothing, no names, nothing, rejected. And other day, when DW2 has completed, and the next day, no witness was brought. 1A exhausted. 1A cannot be kept for till doomsday. Then 2 witnesses have been allowed. Rest were not allowed, not challenged.
No, that is he is challenging. From the list. From the list.
I'm coming. From the list, 2 were allowed.
Rest 5 not allowed. That is he is challenging now.
Come to order. No. That is not under challenge. Page 145.
145.
Page 145.
Order number 200.
Order number 200.
Yes.
On perusal of the list of witnesses in the seal cover list of witnesses. Really, I have never heard it. Very important person, member of Legislative Assembly. How can I give it in the open door? Seal cover. We have also not seen because it's seal cover. It is on the list on the seal cover. It reveals that there are 7 witnesses which the respondent intends to adduce. Out of the 7, 1 Dulal Chandra Das now intends to depose in this case on place of the earlier order. This was the respondent to the TW3, but that's the Dulal Chandra depose on the TW3 and thereafter on council of Subhash Das will tender his evidence as DW4 on further fix by the court. On the other earlier offense, to have this one was filed under taking into consideration the entire factor is totally the prayer of addition further evidence by the respondent. Wife is thereby allowed. Let Dulal Chandra Das depose as DW3 on the next date. Even if the direction passed by to expedite them, if the next step of parties are never done to. Never, why this order court has made clear DW3, DW4? This order has not been challenged. DW3, DW4 has not challenged. Now let come DW3 and DW4, but I mean Dulal and other have been examined. Therefore, he has accepted that order. He has accepted Dulal Das and another one. How he can challenge the different witnesses? 5, only the 5, the other 5. He has accepted the order itself. Yes, Dulal Das and another one will be examined. Now, after this again application, I have given 7 names who have been to allow. And this is the list your lordship has seen. And like repeatedly it was said that illicit relationship with this gentleman I have not. No, with this gentleman. This is come. OB is Moistro. No. Let him show.
From the list.
OB is Moistro. Some other's name is there, not OB is Moistro.
His name is not in the pleadings. Yes.
3 Miller, 1 and 2 allowed.
1 and 2 allowed.
That order. Then on that, thereafter, can any party enjoy the fruits of an order, one part, after enjoying it, can he challenge? Whether it is stopped, whether it is stopped, or because of the doctrine of the stop itself. After the case comes, absolutely afterthought wanting to delay the proceeding. See, who are left? 3. Number 3, my cousin brother. Number 4, I am not no allegation. But if I cannot prove the illegitimate relationship,
Your suit will fail.
what is this? What for? She will come and she will say, no, I am not. I am not. Then I have to find out other person.
Yes.
Then why? Brother of the petitioner, why? Why? This is suspicious. Now it is suspicious. From 2017 to 2025, 8 years have gone. It is suspicious. Then Miller, 6, cousin brother. Fortunately, no cousin sister, daughter-in-law. Others are not there. Why not brought them? Why not the Jaz and Nonods? They will tell everything correctly. Then Miller, 7, distant material uncle. Maternal uncle. Distant maternal uncle.
That Mr. Bachawat says he may not press for this.
No.
Mr. Bachawat, is it your
He has
7?
But he has made the allegation against him in his evidence. He has made the
So
allegation.
are you
Okay.
pressing for 7 also? Because in course of your argument,
I'll
you
take
said
I said they may not be that important. I can take that.
No. Now, point is this, Miller. I have made an allegation against someone. If I cannot summon, then
Yes,
it should not be proved.
6 and 7.
6 and 7 you are not insisting.
Case is not proved.
But
What?
sorry, I got just answer to the question. So as far as my lord, as far as 6 and 7 are concerned, I can show your lordship not in his written statement to the counterclaim and in his chief.
Whether you wish to or you do not
But
intend to.
if your lordship intends, for the sake of not shortening it, I could not say that we will not.
All right.
No.
Yes.
Not me. Mother, can you see? If I have said, referred any names, allegations have been made. Pardon of proof is the same. Why you are worried about my pardon of? And if you are interested to bring them to speak against me, why did you not file the list of documents earlier? Mother, list of see another part of what happened. Consider this. When your lordship should consider good one, consider now. How are we proceed? I am telling you. How are we proceed? Plain, written statement, list of witnesses, documents disclosed. I have to proceed on that case. If someone wants to bring another one, how will you proceed? Everyone has to proceed. Right is only him. He is the right. My right is not there. My right to avail the opportunity to beat the case at that point of time will be taken away. Will be taken away. I have to beat the case. I have to put my case. After knowing fully well what are the materials are available. At the end, you will bring it. How are you doing? My submission with your lordship on point of law is there. Opportunity to Just I'm sending the point. Opportunity or chances to bring the case before the court has to be given to the plaintiff. And before the examination is started, everything should be disclosed. Otherwise, I will do it after finishing my cross-examination.
So according to you, this list of witnesses ought to have been produced or submitted prior to starting of the evidence, your evidence, because
Even although it said 15 days on from the date of settling the issue, let it be
it may be extended.
Court is having decision. I have no objection. Court is trying to extend it. All of a sudden, someone is got. How can it fail? What is the chances? Would it be an unending litigation? And nobody should take that court proceeding as a matter of uncle's house. Anytime, every time, whenever I like, I will do it. Therefore, discipline has to be enforced by your lordship, by fixing, by laying down the law. Everywhere, court proceeding everywhere, a party should be disciplined. Rule of reading, rule of practice, rule of constitution, rule of, it is not just an empty thing. Therefore, it has to be seen in how we have access. I would have made my case also. Why your lordship just that? Extend the documents, extend the entire thing. Well, I should know. All of a sudden, someone is brought. This is not also not rule 1. Although Supreme Court, I will read that judgment, particular that portion. That doesn't mean that such a discretion power, it is an unfettered discretion power. Unfettered discretion power. It cannot be. And it was not the object of the court. Not a single court has any. Court can see, court can do, let it get it very. Court can see, no, court conduct is correct, everything is doing well, everything is going good. This is the witness case. Where a discretion is very, very important for the case. But a matrimonial matter, who are the prime witnesses? Husband and wife. Personally, they have seen the relationship in this closed door. Any witness is there?
Yes.
If this word is here, in court proceeding, you can understand what my client has to face in his life. In each and everywhere, each and every place, every step I am giving objection. Every step I am giving objection. No, I need a quality of life now. I am really tired of. If the proceeding is there, I have given my evidence, everything. How I have spent my life, I know.
Yes.
The quality of life is needed for me today. I am also aging, I am also 65. How long this world will continue to tell me? And do you think, leave aside, do you think that after this, there will be an activity?
Yes.
Now, I'm sorry, I'm taking a lot of time, but I want to finish it.
Yes.
Kind of similar. Then this adjournment, nothing
Yes.
to say. So this evidences have DW3, DW4, then the include or order include your officers. Then we have kindly record that 7th February 2025, 50 minutes arguments have been taken place.
From where you are placing? From?
No, that is not to be disturbed. Just kindly note that.
Yes, yes. Yes.
7th February 2025.
7th February 2025.
50 minutes argument. That was read by them. Argument was done. Then 10th February 2025. 50 minutes. Number 3, 11th February 2025, 30 minutes. Now let's just take it as 1980.
So they have advanced their arguments on 3 dates.
3 days. And another day was 5th when it was Mr. Justice Rai Chaudhary. Justice Raichudhary passed an order, let them file an application. If they file an application for adjournment, that will be considered, judge has considered the matter is pending. And because that time I mentioned the matter was fixed on 19th,
Now it has been fixed on 24th.
24th.
So 19th it was adjourned. 19th no argument.
Prior to that, another 1 day was there. Okay. After the 3 days, there was another 1 day.
Another
On that day it was.
on that date it was adjourned. So on 3 dates arguments were advanced. 4th day it was adjourned. Yes.
Mother, kindly come to page.
The judgment which Mr. Bhattacharyya has.
Yes.
Yes.
Justice will come to page 42 of the judgment.
Yes.
79 from the bottom. There, however, remains an area whereas the party to a proceeding does not desire the assistance of the court for procuring the presence of a witness. Obviously, the party can produce such witness on the date of hearing, and the court cannot decline to examine the witness unless the court proposes to act under the first answer, which enables the court for reasons to be recorded in writing to refuse to examine any witness. Therefore, which is the important date for hearing? And on the date for hearing, no one was present, no witness was brought. The question of this list of witnesses was not required. If this time is any time, then question of list of witnesses were not required. Question did not arise at all.
So according to you, on a date fixed for hearing, a party can bring his own witness.
If I take this judgment, if I ignore even one, if
Yes.
one A, if 1A is one entitled to, even I said that 1A is not entitled to, she is not.
Even
Because of the factual
even assuming for argument's sake.
on even 1A, on the date of hearing, on that date of hearing, I have shown up to your lordship. On that date, no one was present, no witness was there. There were these judgment principles of the judgment not available. You know, judgment law, any law, anything. The benefits of law, benefits of a judgment, only the person who is entitled, the persons who follow the law. Factually, the case is different. I am not saying
This judgment.
factually,
Yes, yes.
But my point is this. My humble submission is, who is entitled to get a relief? Although it's a civil litigation, a person who has come with a clean hand, clear in mind, a person who is delaying the proceeding, times and again. What is the object of this matrimonial matters? Very quick disposal. 2017 to 2025, 8 years have gone. 8 years have gone for concluding the evidence. Because openly saying, in your life you will not get divorced. Let me see.
Yes.
Can I allow Mr. Court?
Yes, yes. New act or the old act?
Old act.
Old act. Evidence act আছে?
I have a copy.
দেখছেন? ওটা নয়? Yes. Yes, Mr. Kaur.
Blood, if your lordship kindly takes 3 sections, 134, 135 and 136. Because my learned friend's contention relying upon this judgment is order 16, rule 1 is sacrosanct. And Lord, if he wants to produce Lord any number of witness
At any point of
at any point of time, the court is bound to allow that. Lord, kindly come to section 134, 135 and 136. These are the 3 sections. 134 says, no particular number of witness shall in any case be required for the proof of any fact.
Called on next day.
130, I'm sorry.
accepting this, সেটা বলে দিন।
This.
Good, I have taken care, you know, Lord, can take up that matter, that environment matter on Monday. But don't, I have taken. But I will argue the matter. But
Yes,
after, until your lordship hears the matter, things should be ordered.
তাহলে ওইটাতে না
Not
Then I'm-
required, but I am taking care.
All right.
Just can rest assured. You see, I'm something on Monday at 2 p.m. or any Monday at 2 p.m. or
মানডে তাহলে একটা অর্ডার রেকর্ড করে
Monday.
আইটেম নম্বরটা কত? 3টে আইটেম আছে।